Good morning, everyone, and thank you very much, Simon, for the introduction. I'm going to kick off, and Toby's going to do more of the hard work. So I just would like to introduce my illustrious panel. As Simon has said, we are all very passionate about this topic, and it's a topic that is just, there's no end to it. We can probably talk for a week about it, but today we're just going to really scratch the surface. So first of all, I just want to get my panel on. Mr. Emmanuel Ozaki. He is probably very well known to many of you from his repo days. He holds a Master of Philosophy degree in Food Science and Technology. He's specialized in product development and food biotechnology. He's got a BSc Honours degree in chemistry, numerous diplomas, certificates. He had a WIPO fellowship where he spent 6 months at the Swedish Patent Office and Registration Office. You no doubt know him for his performance and skills in IP knowledge transfer and capacity building, policy and legal developments, including, very importantly, the establishment of the two repo protocols, Swakopmund and Arusha protocols. And he has traveled the world, no less than 75 countries, done presentations, written numerous articles, and he very recently retired as the IP development executive at Repo, where he managed 3 departments, no less, the Copyright and Related Rights Department, Legal and Policy, as well as the Repo Academy. And he has not been sitting idle since his retirement. He's in the process of establishing the African Innovation Institute in Ghana. He continues to lecture in IP at the Africa University in Mutare, Zimbabwe, University of Dar es Salaam, and in Ghana. He also chairs the IP Network Ghana and serves as board member of numerous institutions in Ghana. So welcome, Mr. Zaki. It is an honor, and as I said to you yesterday, I can only describe you as an IP guru. We're very privileged to have you here.
Thank you very much.
Then we are going to introduce my second panelist is Yvonne Yeboah. Yvonne is an associate with Integrated Legal Consultants in Accra, Ghana. She's a graduate of the University of Nottingham. She has a LLD, and the University of Law Birmingham, where she holds an LLM and has been called to the Ghana Bar. I often work with Yvonne as she handles contentious IP matters, and I must say it is an absolute pleasure to work with her. She is also, my apologies, I see I was still on slide 1. She's also fluent in Dutch and speaks French at a very good level, which is very handy when she has to deal with clients with native Dutch speaking and French speaking clients. And Ntabi has already been introduced. Welcome, Ntabi. And Mr. Stanley Shikuli Atsali is with the Kenya Industrial Property Institute, KIPI as we know it. He has a BSc from the University of Nairobi. He has a master's in IP from the Africa University, Mutare in Zimbabwe. Currently, he is the Senior Patent Examiner Biotechnology, and is also, and very importantly for our topic today, the Institutional Head of Traditional Knowledge and Genetic Resources Unit. Welcome, Mr. Atsali. So, by way of introduction, I think as Africans...
Hi, everyone. I hope you have...
I think he's just saying hello.
Hi. By way of introduction, I think as Africans, we are very much aware of the privilege that we have to be surrounded by traditional knowledge. We use it every day. We see every day the visual feast of traditional expressions. And we tell our children the beautiful folklore stories that we all grew up with. But as we know, when there is something very special and very unique and very beautiful, it needs to be protected. And the indigenous communities and people who developed their traditional knowledge and traditional expressions and folklore over many, many, many generations want to protect those rights, and they also want to promote them, and they want to be recognized for them, and rightly so. And because these are such unique elements and they have such incredible uh, uh, abilities, these are often misappropriated or used without the proper authorization, or used not in the correct historical context. So what we are going to focus on today is how the traditional knowledge and the expressions and the folklore have been protected over the years in IP laws. But as you will appreciate, many of those elements do not fit precisely into the traditional IP environment. So we're going to look at where sui generis laws were developed, or what efforts have been made to do that. So I'm going to kick off straight away with Mr. Zaki as our resident specialist. Mr. Zaki, what is understood by TK and folklore from a historical concept? You have been involved in all of those aspects over the years. Can you perhaps just expand for us on what those terms mean?
Thank you very much, Mariette, and good morning to all. I believe the question or the issue of traditional knowledge is known to all of us. I mean, if you look across the world, from North America to Europe to Asia to Africa to other parts of the world, we have all been associated with traditional knowledge one way or the other. And so technically, it doesn't need any specialized definition, except for the fact that for our purposes for today, I've just chosen to consolidate all the various viewpoints into a kind of operational definition, which is being shown to you at this point in time. So traditional knowledge basically is the knowledge, practices, learnings, teachings, beliefs, customs, innovation, and expressions that indigenous groups over millennia, over centuries, years ago have interacted with nature. They have been able to observe natural settings, and in some cases they deal with cosmological interventions, which we normally refer to as deity, and then in some other cases intuitive experiences. And all this kind of knowledge have been passed on slowly from one generation to the other until today. So when we are talking about traditional knowledge, we are just looking at all these various manifestations, which are the lifestyles of communities that we have, and we call them either indigenous or local communities, or in some cases traditional communities. And this whole body of knowledge, which sometimes in some circles they describe as laboratories of life, is what we call traditional knowledge and folklore. And I have underscored the fact that the distinction between traditional knowledge and folklore is purely academic, maybe just to enable those of us in intellectual property discourse to be able to understand the manifestation of it. So when we are looking at TK stricto sensu, then we are looking at the know-how, the know-whys, how they have used the knowledge to solve problems. And then when we are looking at expressions of folklore, we are now looking at the expressions or the manifestations or the creativity aspect. But we must underscore the fact that indigenous people themselves or local communities, they don't segregate this knowledge into different pieces. They look at it holistically. So basically, this is the traditional knowledge that we have. It manifests itself in textiles, food processes, medical interventions, astrology, and all areas of human endeavor. And that is basically what is traditional knowledge. And of course, if I am mentioning expressions of folklore, then I am relating to the distinctions that we will be having conversation around, to say that all those expressions, aspect of traditional knowledge in whole, is what we are referring to as the folklore. Then the technical component is what we will just describe as traditional knowledge. But to be, and we have to understand that generally speaking, there is no distinction. So when somebody makes a statement without any distinction, we should all understand it. But basically, this is what traditional knowledge is all about. And this is the context in which we are going to discuss this subject matter. Thank you.
Thank you, Mr. Zaki. I think that really clarifies it. Um, traditional knowledge and folklore covers so many aspects of our daily lives, as you mentioned, from food to medicine to conservation to arts and crafts. But why has it become so important to find ways to protect and register the TK system today?
Yeah, I think we just have to realize that during the what do you call it, the post Second World War, you realize that there was this advent of some form of sovereignty issues that arose because a number of countries were taking advantage of other countries in terms of their resources. So if you look at it from 1945, post Second World War, we had the UNESCO being established, and then they talked about the Universal Copyright Convention, and then on and on and on. We saw the 1967 amendments of the Berne Convention, which then sought to consider anonymous works, so to speak. And then you saw even development leading to 1992, the Rio de Janeiro, adoption of the Convention on Biological Diversity, which also brought into some basic principles, one of which is the sovereignty issue. So if you look at this over the years, the IP system has evolved to now come to realize the need for some form of sovereignty of the knowledge or the intellectual property, so to speak, and that has also lent itself towards why traditional knowledge issues have now come into the fore in terms of conversation around traditional knowledge and how best that knowledge can be protected, given that people are taking advantage of this knowledge. There's also the question of equality. And this has gone on for generations, the elements of equity. And so it is also said that, well, if somebody is taking advantage of the other, then obviously the other party then comes up. So if you look at it, it is the developing countries that have served as the demanders for international norm-setting processes on traditional knowledge and expressions of folklore. We must also underscore the fact that we are in a world where competition has become so high that now everybody is looking for anything to be able to produce new products to be able to sell on the market. If you look at the history of product cycles, they have all reduced. Some years ago, there were about 50 years. If you came up with a pharmaceutical product, you could stay on the shelf for 50 years. Now it has reduced. So everybody is now taking advantage of any resource they can find. And I think that is why you realize that today a lot of traditional knowledge, sources are being used to develop, new products, new derivatives, and things like that. Of course, we must also highlight the fact that the TRIPS agreement itself, which was concluded in 1994, and there had also, expanded the scope of IP. Those of us who have been in the IP field for long, you realize that prior to that, countries had the right to determine which forms of IP to protect. But because of the TRIPS agreement, the scope has been open to all fields of technology. So following that, you see the life sciences field growing, biotechnology growing, and the resource base for biotechnology is basically the biological resource or genetic resources. So this has also lent itself towards this kinds of conversations we are having today. And then the last but not the least, which is equally important, the people in the developing world or those in the communities and the indigenous groups, they have also become aware of IP. So now they are asking WIPO for one reason or the other, and I don't have time to go into that, to be able to level the playing field. And I think these are the issues that are bringing about the relevance of traditional knowledge today.
Thank you. Mr. Zaki, I know over the years that WIPO has really made a lot of effort to raise awareness of TK and expressions of folklore. You lived through quite a lot of the process. Can you perhaps just run us briefly through what they've done?
Yeah, thank you very much. I think relating to the RIPO, I did mention that because of all these historical events, this TK issue has come into the main conversation of intellectual property. So no wonder when I think when the patent law treaty was being adopted. I think it started in 1999, in the years before, and then in 2000 there was a diplomatic conference which was going to be, was organized to adopt the patent law treaty. During the diplomatic conference, the Colombia, which is in Latin America, and I think I must highlight that Latin America had also played a significant role in highlighting this traditional knowledge conversation in various international fora. So they took advantage of the patent law treaty to then put on the table the need to talk about disclosure requirements in the patent, well, I think it's a mistake, it's a trademark law treaty rather, the trademark law treaty. So the Director General at that time, thinking that, well, maybe the diplomatic conference had to proceed, then created the WIPO Intergovernmental Committee on Genetic Resources, Traditional Knowledge and Expressions of Folklore to address the questions of disclosure requirements in the patent trademark law treaty and also address other related issues. So if you look at it, during that period again, because this conversation had risen, WIPO had commissioned a fact-finding mission. So all these, converged into the creation of the IGC. And since 2000, IGC started having conversation, and the first session was in 2001, which I participated. And through time, we have discussed various issues regarding the various dimensions, legal underpinnings, questions that are may have some consequential effect in the IP architecture. All of them have been discussed, and I have tried to summarize them in a very simple way for everybody to understand. Some of them include subject matter of protection, nature of the rights, concept of public domain, administration of rights, exceptions and limitations, sanctions, and of course issues to do with classification of the knowledge, and of course the issues to do with misappropriation. So all these issues have been discussed, and I believe we wouldn't have time, probably during the question time, if there is an issue that crops up, I'll be able to clarify them. And I think I'm taking it that this is purely introductory, so I don't want to go too much into details, but I think this is what the IGC has so far done. And I think, as you can see on the screen, I tried to summarize the two key pillars of intellectual property law. The first one is about the industrial property, which sought in at the beginning to address the issues of eligibility and disclosure. And those of us who have read intellectual property from the 15th century, you realize that this was very key. The Berne Convention of 1886 also addressed the concept or the notion of reciprocity, mutual recognition, and unauthorized use. And then the question we are raising today is that is it not about time we also considered the questions of misappropriation, biopiracy, and inequity, which is now the conversation we are having today. So basically, in a nutshell, these are the conversations we are having at the IGC. I must highlight that it has been very difficult, navigating through all these various manifestations, particularly in view of the fact that the classical or the traditional IP system has its own established legal principles, and if due care is not taken, may be tweaked and distorted, given the conversation we are having around traditional knowledge and folklore, albeit it is also very important to acknowledge that the holders of this knowledge also have a claim, since WIPO's mandate, one of them, is to balance the IP landscape. And so this conversation is an open-ended conversation, and depending on where you stand, you may take a certain position or the otherwise. But the issue is that it is an issue that has come to be with us, and we must confront it and address the underlying issues that we are faced on a daily basis.
Thank you, Mr. Ozaki. Indeed, food for thought. You've just mentioned that it's perhaps time to look at an international instrument to address the misappropriation. You mentioned terms like biopiracy, illicit biotrade, bioprospecting, and the erroneous grant of IP rights that we know it actually does happen quite a bit. Can you perhaps just very briefly, because we're a bit pushed for time, run us through those terms?
Yeah, thank you very much. I know we are pressed for time, but I think this is very, well, sometimes very difficult to understand the mischief, the harm. And I think this is what the international discussions seek to achieve, or negotiations are seeking to achieve, whether from the CBD platform, the TRIPS Council, or the WIPO. And we know misappropriation, biopiracy. I will just use two expressions to probably maybe encapsulate all of them. One is our capacity, the right to say no. So the question is, do the indigenous people have the right to say no? And that is what then manifests in the a notion of biopiracy, misappropriation, illicit biotrade, and bioprospecting. The other concept I also want to put across is that do they have the right to be compensated? And I think those of us who know the intellectual property system, there is a compensatory liability regime which seeks to compensate someone if the a compulsory license has been issued. In other words, the person did not have the right to say no, and then his right has been overridden. Then there is a recourse to compensation. So the mischief we are addressing is basically the various principles underpinning the IP architecture, which the traditional knowledge holders are basically using to address their concerns. And I think I wouldn't spend too much time on these because misappropriation has been well defined, biopiracy and all those issues are very well defined. So basically, we must understand that misuse, which is basically the right to be compensated, and misappropriation, which is the right to say no from the indigenous perspective, are the issues that we are discussing here.
Thank you very much, Mr. Zaki. I'm now going to give you a breather and turn to Yvonne. Yvonne, I have read that some decades ago, the Kinte fabrics of Ghana that are so beautiful and so familiar were in fact imitated, and these imitation products were just appearing all over the world. Can you tell us a little bit more about the background of the Kinte fabric and other examples of cultural expressions and folklore in Ghana?
Thank you, Mariette. So Kinte traditionally or historically was produced. I use the term produced loosely here because of the method in which it is produced or it is made for royalty. And the two ethnic groups in Ghana, or three actually, that use Kente fabric, albeit in different designs and patterns. So as you can see on the screen, the northern design applies a more vertical stripe. It doesn't really have much geometrical designs in there. The middle Ewe Kente design, which is attributed to most of the southern Volta regions in Ghana, because the regions have been split now, has more of, I'll say, specific patterns interwoven into the design. And these were made to sort of identify the cultural aspect of the people in there. So some of them have animals, and they were more limited to the daily life instead of the more elaborate and sophisticated designs used by the Ashantis, who used it predominantly for royalty. So in times past, if Kente was woven for a king or a chief within the Ashanti kingdom, that design will not be reproduced to be used by anybody else, which is why these imitations are causing so much problems for Ghana in terms of protection of our folklore, because it's sort of a derogatory use of something that we hold in high esteem. So that's a brief outline of Kente. So as Mr. Saki said, if we decide to go in, it's going to be a history lesson.
Yvonne, yeah, I think you've also shown us the examples of how the Kinte fabric has been used in fashion, and sometimes correctly and sometimes incorrectly. Maybe we can move on to the Adinkra symbols, if you can just tell us a bit more about that.
Yes, so the Adinkra symbols also tie in with Kente designs, because you do have some of the Adinkra symbols woven into Kente fabric most often. And these symbols history has it, were created by a king from Jaman, which is in the south, or yes, within the south part of Ghana, and it was named after him. However, then the Ashanti Empire was on a conquest base and was just conquering everyone. So they captured this king and forced his son to create these symbols. Now, the first one says the ladder of death, tells us about life and its brevity and how death is natural to everyone. Jingame is our most famous and most easily identified Adinkra symbol. You see it everywhere. So you can see it on that plastic chair up there and even in the man's kaftan. And it means God's supremacy. So without God, you can't do anything. Sankofa, return and get it. We use it in Ghana a lot, saying you can go back and start. You don't have to give up. You can start and try again. And Akofina is literally a sword of war. Ako is war and Fina is sword. So it talks about courage and bravery.
Absolutely beautiful. And then moving on to the folklore in Ghana, maybe you can just tell us a little bit about these.
Yes, so folklore, although the acts mention specifically Kente and the Adinkra symbol, we have various expressions of folklore in Ghana. Food, traditional medicine and how it's prepared, songs, dance, various expressions, but we limit it mostly to the Adinkra and Kente because those are the most widely recognized ones. Now, Sansan Kroma is a song, talks about how the hen and the hawk became foes, and it's often told to children to warn them about dangers in society. And the Tutu Bovi is also a song that is often sung to comfort children or soothe them when, say, their mother is away or off to market. And it's used in all tribes in Ghana. It's not limited to just the Ewe tribe. No, everyone sings it because it's so common now. And you have Kwekwa Nanse, our most famous folklore character. And he's known everywhere, all over the world now.
Yeah.
Yes, there he is. However, when it comes to Kwekwa Nancy, although the other aspects of folklore are sometimes used out of context, I believe Anansi as a character is the one that has been widely distorted in terms of how we view him traditionally as a confidence trickster. He's not a good person, or it's not a good character. But in recent times, you've had television series portray him as a god-like figure, as a clever person, and that falls in with using folklore out of context within the parameters of the Copyright Act.
It's very interesting, Yvonne. It's very clear that unauthorized use or perhaps out of context use is taking place. Maybe you can just briefly run us through the provisions that you currently have in Ghana to protect folklore.
Right. So the Copyright Act 2005, Act 690, it provides for the protection of folklore and it sets out what is identified as folklore, although it's a very broad description of folklore because it encompasses so many other things than what is stated within the Act. And the Act grants the President of Ghana the mandate to own these rights. So although they're created by communities, the president acts as the owner of these rights and enjoys whatever economic benefits or moral rights. And there have been discussions as to ownership rights and moral rights are attributed to whoever creates them. So if you're saying it's the president, what about these communities that are actually creating them? What recognition is given to them? And then you talk about compensation there, but that will come under another slide, I'm certain. And then the Folklore Board, which is the monitoring agency, mandated to register, monitor, protect, and even identify all aspects of folklore, is set up under the provisions of the Act as well.
Well, thank you, Yvonne. I think it's very good that there is something, and obviously we'll talk a little bit about the challenges later on. I think we are sometimes approached by clients, and having seen those beautiful elements of the traditional expressions that you have and folklore, whether to ask whether they can use those elements, and what do we tell clients? What is the process that they have to go through?
So because this use or the client's request would be considered as use outside of the context as permitted by the Act, you would require the permission of the Folklore Board, and said permission would be in writing, and a fee that will be determined by the board would have to be paid. There are no set fees because it depends, obviously, depends on what the expression, that particular expression, is going to be used for. And then there'll definitely be a balance of how much remuneration should be applied. So you apply to the Folklore Board, and that is at their discretion, ultimately, to grant said permission, because obviously we're protecting our image as a nation. So whatever use you're going to make of that expression has to be something that would sell our traditional culture in a way. And then when permission is granted, the fee is paid. And this is provided for under the Act.
Thank you, Yvonne. I think we have quite a few questions still, but let's move on to Ntabi for now, and see what the position is in South Africa. And Ntabi, you know that we have a wealth of traditional knowledge and expressions and designs and folklore. What efforts have we made through our existing IP laws and possibly with the sui generis law to try and protect this wealth that we have in the country?
Thanks, Mariette. I think, from a South African perspective, we just have to go to a step back to ask ourselves, why did we have to, recognize our traditional knowledge and the importance of it? And the basis has been that, our indigenous communities have so much wealth of traditional knowledge, and we need to empower them and encourage them to use that traditional knowledge in their, mainstream economic activities. And hence, we came up with laws that will enable us to encourage and empower our communities. And we passed an act, Intellectual Property Law Amendment Act, which will amend the current IP laws so that they recognize intellectual property generated from indigenous knowledge. And we also have the Sui Generis Act, which is an intellectual indigenous knowledge act, in which it promotes and it promotes protection and management of indigenous knowledge. So these are the two acts that we have passed. And when you look at the two acts, they fall under different departments in government. The Intellectual Property Amendment Act falls under DTI, and the Indigenous Knowledge System Act falls under Science and Technology. And they are somehow trying to be aligned to make sure that we protect indigenous knowledge, and we protect our indigenous communities. So when we look at the amendments that are proposed in for the IP laws, we are looking at amending the Performance Protection Act, which will enable us to protect performance of traditional works. We have so much diverse works and it's easy for somebody to just come and pick up and say, this kind of a dance, it belongs to me, and we need to protect, those traditional works. And also we are looking at amending the Copyright Act, which will enable, us to have a national database of indigenous knowledge. And we're also looking at amending the Designs Act and the Trademark Act, which will, provide for a additional register which will recognize registration of indigenous terms and expressions. And when we look at the act that is specifically concentrating on protection of indigenous knowledge, that on its own, I think, it covers a lot of things. It highlights the need of having a registration system, that like Mr. Saki said, can our communities say no? And this act gives the power to the community to say no. They have the power to say, yes, you can use, no, you can use, and we can give you the right to distribute our knowledge. And also the act gives perpetual rights, unlike what we have in our IP laws, where rights are limited and you have to maintain them and they can lapse. The Indigenous Knowledge System Act provides for perpetual rights. It doesn't lapse. It's for the community forever and for good. And also, if it happens that the indigenous knowledge has to be commercialized, the Act provides for licensing, because the main aspect of the Act is that the community must share in the benefits that are generated. So that's why it provides for licensing agreement and making sure that there's benefit sharing. And the other good thing is we anticipate that there will be conflicts, there will be disputes, but the good thing is we don't have to rely on our courts. We will have an alternative dispute resolution, which I think will be faster and quicker, and it will enable people within the communities to come and try to resolve their issues. And when you look at these pieces of legislation, you would think that there's a gap somewhere, more especially in current practice. But I think we were proactive as a country. In 2005, we amended the Patents Act, and we amended it in a way that I think WIPO said it's one of the model laws, to make sure that if you are coming up with an invention and it's somehow derived from traditional knowledge, you have to declare in your application form to say this is derived from a traditional knowledge. And if you fail to declare that, or to file that declaration, your application will not proceed to grant. And if you falsify the information, there's also a recourse. We can apply for revocation of that patent. So when our clients come to us, at least from a patent perspective, we can tell them, this is what you need to do. We need to declare if it was that the invention is generated or is somehow linked to traditional knowledge. Then there are steps that we need to follow to make sure that the community, the indigenous community, will benefit from those rights.
Thank you, Ntabi. I must say I'm super excited about the Indigenous Knowledge Act in particular, because it really addresses the issues that we feel are so important: the perpetual rights, registration, making sure that the community has a choice, and then also making sure that they can get money. And as you say, no doubt there will be disputes, but it is a great start. What is the time frame for these laws?
Mariette, it's difficult to say, when will all these good acts and amendments will come into force, even though there's been some progress. Now the two legislations are acts of parliament, but we do not have the regulations. And there were reports that, we are hoping that the regulations for the Intellectual Property Law Amendment Act, will be finalized somewhere in 2021. And the regulations for the Indigenous Knowledge System Act, they are 90%, almost done. So it's difficult for us to estimate, when.
Any moment.
We're hoping any moment, but between years, we don't know.
Thanks, Tommy. That was very interesting. Moving now to East Africa, Mr. Atsali. You have been very much involved in the process of protecting traditional knowledge in Kenya. And I know there is a policy framework, and you can perhaps provide us with a bit more information about how it works and what's the background.
Thanks, Marita. Are you able to hear me?
We
So in
are.
the Kenyan time, thank you. So in Kenya, it's just midday, so allow me to say good afternoon. I appreciate Mr. Saki's presentation, and we build on Thabi's bit of it. Now, as I said, from the Traditional Knowledge and Genetic Resources Unit, where these issues are of great concern to us. We realize that Kenya has got all the biodiversity. We have got we normally say that the whole world is in Kenya, because you can get biodiversity that can withstand very cold conditions on the top of Mount Kenya. You can have biodiversity that can stay in fresh water around the lakes. You can have biodiversity that can survive under saline water at the coast and intermediary. So then the concern was that we have got all the biodiversity and we have got knowledge holders. How come we are not benefiting from this? And yet, when you look at China, for example, it's talking of billions in this particular area. So before I come into this, there was a concern, as Mr. Saki said, it started off at the IGC. So we were concerned that the process at the IGC was not moving on as fast as you would like, and biopiracy was continuing. So in 2006, the Attorney General developed a task force that developed the policy actually based on the challenges that we were addressing at the IGC. So this task force did some work. Most of the work of the task force was incorporated into the Amalgamated Constitution of Kenya of 2010, particularly in Articles 11 and 69. 40.5 recognizes intellectual property as property. So generally, that's how the progress has been. Then being Article 11 is a consequential act, so we had to develop implementing acts. So the parliament in 2016 passed the Traditional Knowledge and Traditional Cultural Expressions Act of 2016 that addresses issues related to traditional knowledge and cultural expressions. But in my talk, like if I may give you the background of Kenya, IP is protected by three main institutions. KIPI, the Kenya Industrial Property Institute, handles the industrial aspect of it. The Copyrights Board handles the copyrights and related aspects of it. And the Kenya Plant Health Inspectorate Services handles the plant breeders aspects of it. So broadly, that's why I said I might not talk so much about the cultural expressions, though this particular act gives provisions for both traditional knowledge and cultural expressions. I think that's the general on the legal and maybe the policy and legal aspect of our protection of traditional knowledge and cultural expressions.
Thank you, Mr. Atsali. I mean, I feel as if I'm in Kenya after you've told about the mountains and the lakes. It's just wonderful, the incredible biodiversity that you have. Now, in view of the fact that the laws are still relatively new, I'm just interested in what challenges you have faced since implementation. And this is a nutshell. There's obviously a lot more that you can tell us about it.
Yeah, thanks, Mariette. Now, the challenge now is I'm also in Thabi's situation. The implementing regulations. The Traditional Knowledge and Traditional Cultural Expressions Act of 2016, as reviewed in 2018, has provisions in Section 43 for development of implementing regulations. So that's where we are right now. There's a task force where I thank God I'm one of them, tasked with the responsibility of developing the implementing regulations. Now, if you look at it, the way the act has been crafted, the real players are the communities under the custodianship of the 47 devolved units. Kenya has got 47 devolved units. We call them counties. So each county has to develop a repository for traditional knowledge and cultural expressions. Then KECOBO, the Kenya Copyright Board, is the national repository. Now, that's one aspect. So it means that we have to build capacity in the 47 devolved units to manage their repositories. And then KECOBO has to develop capacity for managing the national repository. Now, where is the challenge? The challenge is in the definition of what genetic resources is. The Act defines genetic resource as microorganisms, plants, and animal material, including indigenous seeds, genetic plant varieties, and traditional animal breeds. Now, as a member of the task force on developing regulations for microorganisms, our patent law is clear on it. We have got in the Industrial Property Act of 2001, Section 29 gives provisions for the protection of microorganisms, and implementing regulation Regulation 11 gives institutions that act as depositories for the microorganisms. So we believe that as we move on with traditional knowledge as genetic resources, those two, that part of the act, the Section 29 of the Industrial Property Act, will need to be amended to call for disclosure of source of origin of the traditional knowledge that could be used in any patentable invention. But now, in a nutshell, maybe Mr. Saki might understand this. When we hear something about traditional animal breeds, which is already in our law, we realize that there's a gap, because for plant varieties, we have got the capable Kenya Plant Health Inspectorate Service, which will develop regulations based on that. But for traditional animal breeds, we realize that there's a gap. And is there a need? Yes. Kenya has got a pool of germplasm in form of traditional animal breeds, and we have got our famous red Maasai sheep. It has been there's been some crossbreeding with the Dopa from the South Africa, and we know the products that can come out of it. But more interesting is that the red Maasai sheep has got anti-helminthitic characteristics in that anybody would pick the red Maasai sheep and crossbreed it with any sheep in their territory to create the anti-helminthitic characteristics. And as Mr. Saki said, the basis of developing these laws is to apportion benefits to the communities. Communities have been taking care of these genetic resources, and we believe that any access to it should also be accompanied by benefit sharing. So what we are proposing is that as members of the TRIPS agreement and as the members of the Convention on Biological Diversity, harmony could be created if there's a disclosure of source of origin of genetic sources in any IP protection, be it industrial, where KP will be, or plant breeders, where
Mr. Atsali? Sorry, I'm not sure if we've lost Mr. Atsali there. It's certainly a lot of food for thought. Ntabi, we're running a little bit behind with the schedule, so I'm not sure if you want to add anything about the challenges that we are facing in South Africa.
Briefly, Mariette, I think the current challenge that we're facing is trying to force somehow indigenous knowledge into the IP system, and these are just they are two separate systems, and yet we know we are trying to force it. And I think it's one of the reasons that academics already are calling that, our laws, the laws that have not even been yet enforced must be amended, and let's relook at, what we want to achieve. Because for indigenous knowledge to be registered under our IP acts, it will have to pass some, IP requirements, technical requirements and all that. So it will be very difficult to force indigenous knowledge into the IP system. Thanks.
Thank you, Ntabi. we've got a bit of a mountain ahead of us with that one, I think. And then coming back to Ivan in Ghana, if you can just sort of touch for us on the issues that you are facing in Ghana.
Pardon me. So with regards to the enforcement of the provisions of the Act, and with respect to seeking permission where you want to use such expressions outside of the context or for commercial purposes, there's, to the best of my knowledge, there's no set task force besides the Folklore Board itself that sees to the proper enforcement. And when you take into account the fact that separate communities consider different things as folklore, I make mention of what kind of database in terms of the designs of Kinte, for instance, exists for you to apply to say, okay, when you need to use this, you have to check this database and see who created it or which community it came from. So that is something I think the Act should be amended to consider as well. And lack of policy direction. Coming together with most of the policy players in the IP industry and not limiting it to just the copyright, where it's literary works, artistic works, but as Ntabi said, you can't just fit all expressions of folklore within one particular IP rights. They vary, and so different expressions will apply. For instance, plant rights. You're looking at design rights, industrial design rights as well. You're looking at patents and even trademarks. Some of these expressions could be branded to be considered as trademarks and not necessarily copyrights.
Yes.
And you're looking at domestication of international laws and treaties. I do know that Ghana is party to the Convention on biological diversity, but as to whether it's something that most people even know about is also another issue. So education in that sense to integrate such treaties within our local legal framework, if I should say. And then there's also a dearth of case law, because although you have instances where expressions have been utilized by, I'll say, producers, and these are major movie houses, television series, you don't really find that there's been any prosecution. And I have to say here that the Folklore Board has indicated that they do not seek to prosecute, they wish to attribute. So where you use these expressions, you attribute them to Ghana, to maybe the Ashanti region, Bonre, where some Kente is made, or to the Volta region as well, or to the northern region, and to let people know that this is where it came from. And that would also help to circumvent the issues of piracy, because everyone sees it and knows immediately, oh, okay, it's from Ghana. It's from this particular tribe. It's from this particular community. So that is something that we have to consider. So it could be arbitration, but not necessarily prosecution or litigation.
Yes.
We're looking at, well, the mechanisms also tie in with the lack of proper enforcement, because when you have them in place, it's how you're able to enforce the laws. Because you are culpable if you infringe or if you detract from the law, which says you have to seek permission. There's a fine, there's a prison term, or both. So it's something that the Folklore Board has to really consider. As I mentioned, the non-existence of a database where Kinte designs and the Adinkra motifs may be easily identified. You do identify most of them. For the Adinkra, there's an index you can find on Google with a couple of the Adinkra symbols, but it's not exhaustive. It's not everything on there. And with the Kinte, there are about 50 different types of patterns or designs. However, the names, attributing them to which tribe or which community, that is something that has to be taken into account for ease of reference for anyone who wants to use it. And then you also attributing it to the communities would help them in terms of the revenue that's coming in. So one community doesn't say this is mine, but you have to consider the cross-border challenges as well in that instance, because you have the Ghana Evers, you have the Togo Evers, and they share similar expressions, if I may. So that also has to be taken into consideration. And the rights held for the people by the president. There is supposed to be a fund where all the royalties are paid into to help develop folklore or traditional knowledge in Ghana. But there's also the issue of the perpetuity of these rights because they're vested in the state and not in a particular person. So they will never become part of the public domain and no one is able to use them again. Oh, yeah. My slide is missing.
Thank you, Yvonne. We can carry on for hours about this, and I think there's a thread running through of the database, the enforcement, the recognition that we hear for every country. But I very briefly, Mr. Ozaki, I think we want to consider maybe a policy or a legal options for the protection of TK and folklore in Africa. And I think some pattern has come through this. I don't know if you can say in one sentence, perhaps, because we're running a bit late. What do you think about that?
Oh, thank you very much. I think it has been a long discussion. Quite useful in any case. But I think before I just quickly run through this, just about 2 minutes. So just time me. I think we have all realized that there's a wide range of traditional knowledge in our countries. Some secret, some sacred, some widely known, some not widely known, and the like. So the important message here is that people are collecting these inventories, and so we bear that in mind. There's also the point of the fact that a lot of national efforts are being made to develop policies, legislations, and what have you. And I think it is in that context that these policy options will be helpful to the countries concerned. And I think they are very clear. One important point I want to underscore before I just 1 minute highlight this is the fact that remember all these things will come with transactional costs, administrative costs, and then they will have some kind of interplay with the conventional IP system. So those of us who are practicing IP, we bear this in mind in our discharge of our duties. In view of that, I think we have all these options. In cases, I think I heard a whole lot of information from the three other speakers related to the use of the IP system to protect some aspects of traditional knowledge and folklore. You can also modify the IP system just as it happened post 1967. You saw a lot of African countries modifying their copyright laws to incorporate folklore issues. Then, of course, the most important thing I'm interested in is the sui generis option, which ARIPO has done through the Swakopmund Protocol. And that it gives it more comprehensive approach through that. And I believe the other point is about the customary laws and the protocols and the practices. Can they be institutionalized? Can they be formalized? So these are various mechanisms by which the knowledge can be protected. And I think we must bear that in mind in proceeding with our national reforms and development of legislation at the national level. Thank you.
Thank you, Mr. Ozaki. I know you've really talked about it, Yvonne, a little bit about what you want to do. So I'm going to skip this slide if it's in order, because we just want to very, very briefly, Mr. Ozaki, maybe talk to us just about, I don't know, we're running so out of time. If it's possible to say one sentence about regional initiatives and then just tell us a little bit about the repo and the Swakopmund Protocol.
Yeah, thank you very much. One sentence, regional initiatives. Well, I think we know there are various regions around the world, and I think I provided this just to help with the documentation. I can't go into that. You know very well
Okay.
that Aripo has that framework. Then this is also the beginning of Aripo processes. I must underscore that when we were developing the Aripo Swakopmund protocol, it didn't just come by, dint of we taking somebody's framework to build on it. It was just a consolidated and a synthesis of various policy of documentation that we consulted. So I've highlighted development policies, we consulted science and technology policies, we consulted indigenous people's rights and policies, we consulted, and of course, environmental policies. So all the issues that you are dealing with, you are seeing on the screen, they have been consolidated based on existing policies. And this is what now has led to the Stockholm Protocol. So the Stockholm Protocol is now in place. It entered into force, I think, on May 11, 2015. So now it is operational. So any local community in your countries are eligible to apply, provided they have all their elements put together, so they can apply and then they get registration from the ARIPO office or through the national office, as the case may be. And then, of course, it is very important that when they are applying, they indicate in a descriptive manner how the knowledge is applied and the utility of the knowledge. And then they make a token payment of 50 cedis, dollars. I'm just in Ghana, so I thought it's cedis. It's dollars and things like that. $50, and then when it gets to registration, they pay $50 dollars as well. Very simple system. And I must indicate that we have incorporated non-disclosure requirement agreement in the regulation. So if the community concerned do not want us to share the knowledge, we do so for them. Then the repository for containing all this information is a database which is on the screen. I wouldn't have time to go through that. So just bear in mind that Aripo is developing a database, what we normally refer to as constitutive database, to be able to put in all the information that we will collect even from them. And there are three levels. The third one is a confidential database, so it is never open to the public. Only the abstract can be read, and then if a third party want to access the information, then they go through prior informed consent and then the mutually agreed terms. So basically, this is in a nutshell what Aripo has done, and I kindly encourage your people to make applications. It will help them a lot to, first of all, codify the knowledge, and then it will also provide legal certainty as we travel the journey of incorporating TK issues into the conventional IP system. Thank you very much.
Thank you very much, Mr. Zaki. I think we just about finished with our time, so I just want to thank my panelists for their wonderful contribution. It's really been a journey, even though we've only touched a few corners of Africa. And seeing that our theme is African Dream, I want each of you just to give me one sentence of what would be your dream for the protection of traditional knowledge and expressions in Africa. Maybe starting with Yvonne, seeing that Mr. Zaki has just ended. Yvonne, any thoughts? We may have lost Yvonne. Ntabi, can you perhaps give us a thought?
Yes.
Oh, there's Yvonne.
Oh, Yvonne is back.
Yes, I'm back. Dream is incorporating all forms of folklore expressions as much as possible within particular rights, so the people are protected. That will be it. Yeah.
Fantastic. Ntabi.
My African dream will be, to see these laws being implemented in a way that, our indigenous community can say we are benefiting and we can see the changes in the community. Thanks.
Brilliant. Mr. Atsali, I'm not sure if you're still with us.
Yes, I'm still there. My parting words will be our culture, our civilization. Thank you.
Fantastic. And Mr. Zaki, as the guru of TK, what would your dream be? That we follow the Swakopmund protocol?
Oh, no, no, it's just to consolidate all the views that have been expressed. Thank you.
Thank you very much, everyone. It was really wonderful. I'm not sure that we've got time for questions now, but we can address them by email if anybody has any questions. Thank you, Simon.